record it. Or can you record on the phone? Let's see.
I think you can.
Chat, meeting settings, background, disconnect. Maybe not.
All right, everyone. Welcome back to the main room. Now, this is one of my favorite time. Turn on your camera, show your face, and give me the big two thumbs so that I can take a nice screenshot.
Right.
All right. Steve. Crazy Doc. Teresa. Yeah, I'm gonna wait. Hold it. I'm gonna wait until everyone turns it on. So, you know what? Those two people. Okay, right. There you go, Teresa. And Crazy Doc, whoever that is, it's not turning on. Anyway, I'm going. Steve.
I think it's Sidekick.
3, 2, 1. One more. 3, 2, 1. There you go. Okay. All right, Nico. Who do we have tonight?
All right, guys. So Joseph and I, we hogged the stage for a little while. I apologize for that because the real host is coming up right now. His name is Nic McGrue. If you don't know Nick, he's an attorney at Polymath Legal PC, where he handles transactional matters in the areas of syndication, real estate, business, and entertainment. This is going to be perfect. Nick received his undergrad degree from the University of Washington. And while at Washington, he was a student radio talk show host, the vice president of his fraternity, an officer in a business club, and the founder of a pre-law club. This guy, I don't understand how he's got so much time to do all this stuff, because listen to this. He received his Juris Doctorate degree from Pepperdine University School of Law. At Pepperdine, Nick was a journal editor, a student government officer, and a moot court board officer. He focused his studies on business, entrepreneurship, and real estate. Nick also holds an LLM in taxation and financial services with a certificate in U.S. tax. Nick is admitted to practice law in California and Washington State, and he holds a California real estate broker's license. In addition to working on various entrepreneurial ventures and running his law practice, Nick is a tenured professor at business law and teaches business and real estate classes for undergraduate, graduate, MBA, and law school students. In his free time, I don't think he's got any, Nick enjoys cooking for his fiancee, playing saxophone, that's awesome, hiking, studying card and close-up magic, and learning about new topics that pique his curiosity. Welcome,
wow.
Nick.
Wow,
thank
that was
you.
wow,
Thanks
Nick.
for the introduction, Nico.
You're welcome, man. You're welcome. Really happy to have you here. So, you can just give a little bit more context of who you are, and then we can jump into this.
All right, let me get the slide set up really quick. All right, can you guys see the PowerPoint slide? All right, I've got multiple monitors, so I'm not sure what you guys can see or not. All right.
Yes. Slide. And everyone, if you can mute yourself, and then if you have any question, you can actually leave in a chat box. And as you leave in a chat box, and as we get to the end, we'll address the questions one by one.
Yeah. So thank you for that introduction, Nico. Joseph and Nico, thank you so much for having me here. So what I'm going to go through, I'm going to go fairly quick because I want to leave a good amount of time for you guys' specific questions so we can interact that way. But I created a quick, small presentation based upon some questions that Joseph posed to me. And so we'll go through those. And like you said, please write down your questions in the chat. I probably won't be able to necessarily see them as I'm going through, but we'll definitely do our best to make sure that we get a chance to discuss everybody's questions and get answers for them. All right, so the first question that Joseph wanted to talk about is just LLCs generally. And so with LLCs or limited liability companies, when you're looking at choosing an entity, these are, from a legal perspective, 4 things that I often will tell clients we want to think about. We want to think about, what is our liability? So if the company has debt that it can't pay for itself, who is going to be responsible for paying that debt? Is it going to be the company and just the company, or is it going to be the owners of the company, which is you guys essentially? So one of the great things about limited liability companies is, as the name suggests, they have limited liability, which means as an owner of an LLC, assuming that you're treating it how an LLC is supposed to be and having separate bank accounts and that sort of thing, If the LLC incurs more debt than the company can pay, the worst that can happen is you lose the company and all the assets that it has, but all of your personal assets are going to be untouched. And so I know that it's not great to lose anything, but it's even worse to lose your company and then lose your car and your savings account and things like that. So limited liability protects that from happening. The other big benefit that LLCs have is with taxation. Some entities, such as corporations, are taxed twice. So when the corporation gets money, it's taxed with corporate taxes. And then when it gives dividends to the shareholders, they have to pay personal income on what they receive as well. With an LLC, there's what's called single taxation, or sometimes called pass-through taxation, which means that the LLC gets money and all that money passes through the LLCs and flows directly to the owners. And then the owners are taxed on it as personal income. So you're taxed just once instead of twice like a corporation is. And then the other two are a little bit less important, but still things to be concerned with, is management and control. How does it have to be managed? Who has control? How strict do we have to be or not? With corporations, we're going to have minutes for everything and have a paper trail. There's a good amount more of red tape. Whereas with an LLC, you can kind of handle these things as however the LLC agreement says that it's going to handle it. So you have lots of flexibility. So that's one of the reasons that I like LLCs a lot. Now, they are not the be all end all, and I do form entities outside of that. But a lot of times after I talk with a client and we go through this and get to know what their business is doing, the LLC often ends up being one of the better choices. But again, there are some unique situations that may differ that. And so particularly when you're thinking about this, you also will want to talk with a tax planner if you have one, because while an LLC does have single taxation, there are other entities that might have tax advantages for you. For instance, an S corporation sometimes, depending on your situation, might have some good tax perks for you. So in the syndication and real estate world, I hear LP and GP a lot. And I see that even when we're dealing with an LLC, which technically does not have LPs or GPs. Instead, an LP or a limited partnership is actually a different type of entity in and of itself. I do still see some syndications set up this way. I have not personally found reasons, at least with my clients, as to why we should, or how an LP is going to be better for them versus an LLC. And I'll kind of explain quickly why. With a limited partnership or an LP, you have two classes of membership. You have at least one general partner and an unlimited number of limited partners. The general partner is always personally liable for anything that happens in the limited partnership as a whole. The limited partners are only personally liable if they are the ones that cause the debt or cause the creditor to come after the company. But in any case, there's at least one person that's going to be personally liable. Whereas with an LLC, you can have a manager that's controlling and having the same type of authority that a general partner of a limited partnership would have. But the benefit of an LLC is that management entity or management person is also going to have limited liability. And so I see LP a lot in real estate. I've talked with colleagues, and the only kind of justification I've come up with as to why I still see these is for a long time, it was the only or one of the better options. LLCs are still fairly new. They just got widespread adoption in the mid-90s. And so in the scheme of business, still fairly new. And so my guess is that there were people doing this before LLCs were popular or even an option, and they've kind of just kept with their same format. At the end of the day, probably not a whole lot of exposure that you're getting into with an LP versus an LLC, but I kind of say, why have even the chance of the exposure when an LLC can protect against that very clearly? So should you have an entity for your passive investments? Since we're talking about LLCs, that's one that people often might have as a holding company. With a passive investment, I'd say I'll give the lawyer's favorite answer, which is maybe. It really kind of depends on what is the potential risk that your investment has itself. What is your own personal risk tolerance? Also, what is the structure that your investment is set up as? For instance, if you were investing in a true LP where we have the GP and the LP, remember, as I mentioned, limited partners, if they are the one that caused the debt, they can be personally liable. So in that situation, I'd say, yeah, we should have an LLC there, because even if I invest as an LLC as a limited partner, and as the LLC limited partner, I cause some sort of debt, well, the worst that's going to happen is that my LLC is going to, the assets in that are going to be taken. But again, my personal assets will be protected. It's always a balancing act as to, you know, how many LLCs should I have, or should I put this in one or that one? All things being equal, to be the safest, I'd say, yeah, for every new asset, for every new revenue stream, create a new LLC and have them all separated and separate from each other. However, I understand all things are not equal. You know, those have costs. You're going to have annual filings you have to do, and payments for those as well. And so I usually say, look, it's a balance of what is your risk tolerance and your perceived risk, and also what is your administrative capacity. Because in most people's situation, it doesn't make sense to have 50 LLCs and paying 50 filing fees and 50 annual fees, but it might make sense to have maybe 2 or 5. And so a lot of times with clients, we'll start off with maybe 1 or 2. And as they start expanding and growing, we take a look and reevaluate what those risks are. And we might create new ones from there. So another question with LLCs is, where should I create it? We hear about Wyoming a whole lot. Delaware's another one. Nevada's one I hear a lot as well. Texas also. What are the benefits of those different states? And what are some things we should be thinking about? So a couple of things. If we are filing or creating an entity outside of the state where we reside, we're going to be required to have a physical address in the state of formation. So if I create a Wyoming LLC, I'm required to have a physical address in Wyoming and somebody that stays there that serves as what's called the registered agent. The registered agent is basically the person who is going to receive official mail. And mainly it's really there is, if you're getting sued, who should we be sending this, this complaint to? And so that's one thing to keep in mind, is that if you go out of state, you're going to need a registered agent. There's some costs involved, not huge. A lot of them range from about $50 a year to about $125. So there is some cost involved, but there's companies that take care of that. So if you say, oh, I'm in California and I want a Wyoming LLC, but I don't want to buy a lease or get a lease or something like that, no worries. There are companies that say, hey, I'm a registered agent. I've got a physical address in this state. I'll be the person. But that is one thing you want to keep in mind. Another thing you want to keep in mind is that if you are conducting business outside of the state that it was formed, then the state where you're conducting business might require you to register that entity as a foreign entity. So again, let's say that I have a Wyoming LLC and I'm in California and I'm going to open up a coffee shop. Well, that is clearly an example of conducting business. So I either am going to have to register my Wyoming LLC as a California foreign entity, or I'm going to have to just create a brand new California entity. And so that's one thing that you also want to think about. Now, what exactly is conducting business? It's not super clear, but most states have said if you have a lease, so if you're leasing real estate, or if you have a place where the general public is allowed to come, then that's definitely conducting business. Now, if you're doing say maybe a fund or maybe some e-commerce and you're just doing it in your home, probably not conducting business, and you probably will be okay without doing that foreign entity registration. In any case, if you're going out of state, those are some things you want to think about. Now, why Delaware or Wyoming? Delaware was the big shot for a long, long time. Delaware said, hey, we want to have businesses come here, so we're going to make sure that we set laws that make it fairly, or at least simpler for businesses to conduct business. And so some special perks that Delaware has is they have what's called a special business chancery court. And what that is that if there's ever any business disputes, so members, shareholders, partners, that sort of thing, if they're ever having any disputes, there's a special court that those disputes are going to be heard in. So instead of with most litigation issues, at least I know in California, our courts are backed up for a long time. If you're trying to have a lawsuit, it's going to take you about 2 years to get it here in California. Other states, probably not as long, but it still takes quite a bit. With Delaware, they say, hey, we have a special court just for these business issues. And so there's a chance that you might have your matter heard a little quicker, or at the very least, you're not going to be lumped in with a divorce and a car accident and a breach of contract and all sorts of other things. The other benefit of having that business chancery court is that you have judges that are very well versed in business and business issues. So with that, you're likely to have at least theoretically have a better outcome, because most judges, or not, at least not all judges, know a whole lot about business. Some of them were prior litigators who don't really do much business at all. So these business chancery judges have lots of business experience. Another benefit of that court is that there's lots of case law, because they hear lots and lots of cases. And so there's lots of case law. And with that, one of the things in law that we try to do is try to predict what will happen. And so if we can see how a court dealt with a situation in the past, that'll give us good guidance as to how they might deal with the situation we're dealing with. And that might inform us as to maybe we should pursue this lawsuit, or maybe we should settle it. So those are some of the reasons why people like Delaware a whole lot. Delaware also has what's called a strong charging order, which essentially says that if any of the members have creditors coming after them, and that creditor is entitled to their entity stake, all that creditor can get is the profit participation. They'll have zero voting, zero authority at all. So those are some of the reasons that people like Delaware. Wyoming has a lot of the same benefits. They've got a strong charging order. They do not have that business chancery court, however. One benefit that Wyoming does have over Delaware, though, is that you have the ability to be a bit more anonymous. Most states, when you create an LLC, you have to name one of the officers or the members or the owners or something like that. And that's public record, and people can fairly easily find that. With Wyoming, you're required to provide an email address and a phone number. And so depending on what your email address is, or if you have a phone answering service, it can be very unclear as to who actually owns this LLC. Now, if they really wanted to find you, they can find you, so you're not completely anonymous, but it's going to take a little bit more work. And so if there's somebody that's thinking of suing you for something kind of frivolous, and they can't even figure out who you are, they might say, oh, this is not really worth it. So that's some things about Wyoming. Another thing that I love about them, and this is probably more benefit to me as someone who files these a lot, is that Wyoming, you get it back instantly. Even during this presentation, I could create a Wyoming LLC in about 5 to 10 minutes, and I'd get the certificate of formation back right then and there. Delaware, I don't like Delaware because they're still pretty slow. They still use mail. So you can file it online, but they mail the official confirmation back to you. And right now I have one that we've been waiting for about 2 weeks on, and don't know where it's at, don't know what's going on. Whereas with Wyoming, the moment I file that, pay the fee, I get it back right away. So I'm more in the Wyoming camp than I am in the Delaware camp. But hopefully these will give you at least some insights as to what you should be thinking about if you're thinking of going outside of your state, and what some of those benefits are. So a lot of people have some questions on what is a joint venture versus a security, or how do I know, or sorry, what's a joint venture versus a syndication? How do I know when I need one or the other? So a joint venture, and one thing I will say at the jump of this is that many times, at least in real estate and in the real estate syndication general industry, I see this done incorrectly. And when I tell clients, no, you can't do that, and they say, well, I saw this group do it. And so the example that I give to them is I say, look, I drive fast, I drive over the speed limit often, knock on wood, I haven't gotten a ticket. It doesn't mean that I'm not violating the law, it just means that I haven't gotten caught. And so if you see people doing things improperly, doesn't mean that, oh, it's okay to do. It might just mean that that's a law that hasn't necessarily been enforced upon them. So with a joint venture, It essentially is a limited, and I should use my words carefully here. It's a limited duration or limited scope partnership, to where you have a couple of parties coming together with different skills or different things that they bring to the project. And then once they finish that project or meet their objectives, they kind of part ways. So that's what a joint venture is. Some syndications can be set up that way, but a joint venture is not a situation where you say, hey, I've found a great asset. I've vetted this, I've underwritten this. Now I need, I'm going to get 10 people and they're all going to raise capital so I can acquire this asset. If those 10 people are not licensed broker dealers, that's probably not advisable for you to do, because you're probably violating some securities laws. One way to make sure that you're not violating those securities laws is to do a syndication. And if you are selling a security, then you're going to need to do a syndication. And so when I tell clients this, the next question I get is, what is a security? The way we figure out what a security is, it comes from the Howey test. It's a case, I believe it was in 1946, but still strong, still stands as the law today. And the Howey test asks us this, and if we say yes to all of these, then we have ourselves a security that we're selling. So the Howey test says, if there's an investment in a common enterprise with an expectation of profit, primarily from the work of someone else, that is a security. So again, if we're investing into a pool or a group and I'm expecting to get money and I'm expecting that I'm going to be a passive investor, I most likely will fit the Howey test, which means that I am buying a security. And so the person that's selling me a security, the SEC says, if you're selling a security, you either need to register that security or have an exemption. Registration is, if we hear about all these IPOs and publicly traded companies, that's the registration process. I don't deal with that. It's more expensive than the work that I do, longer process, not what I do. But registration is one way to do it. Or the other way is through exemptions. And with real estate, exemptions is usually what we'll use. Again, there can be registered real estate projects, such as a REIT. That's an example of a registered security. So for exemptions, a common one that's used in real estate is Regulation D. And I know I'm throwing a whole bunch of acronyms and stuff out at you. Within Regulation D, there's two different types of exemptions that you can use, 506B or 506C. And they're a trade-off. Clients say, well, how do I know which one to use, this one or that one? I usually tell clients, look at where your network is, or look at your network that you think is likely to invest and see where more of them fall into, and that's probably the one you should use. So let me explain kind of the difference between the two of them. Before we get into that, I just want to get into the quick definition of the term I'm using. So you'll hear me say accredited investors and sophisticated investors. For simplistic terms, an accredited investor is somebody who has made $200,000 or more the last 2 years and reasonably expects to make that much again this year. Or they have a net worth of $1 million or more exclusive of their primary residence. So they're worth $1 million if we take out the house that they live in that they own. And there's other ways, there's many other ways to do it, but those are the common ways of how most people qualify. So you make $200,000 or more, or you have a net worth of $1 million or more, then you're likely going to be accredited. Sophisticated investors are not accredited, but instead between their experience, their education, their work, or their current investments, they possess the knowledge necessary for them to be able to reasonably vet and investigate in the security that they're purchasing. So basically they have some business acumen, they understand a little bit about stocks and securities, and can read through a PPM or a pro forma and understand generally the things that they should be looking at for themselves. So with those two definitions in mind, let's go back to our 506B and 506C. 506B allows you to have an unlimited amount of accredited investors. You can also have up to 35 sophisticated investors, but you are required to have a pre-existing substantial relationship with them. And so what that means, again, I'm talking in generalities. Generally, you know them before the deal is on the table, and you know their finances well enough to know whether they are sophisticated, accredited, or otherwise. So if you have a deal on the table and you meet them late after that deal's on the table, they can't come into a 506B because you don't have that pre-existing relationship with it. Then with 506C, you can have an unlimited amount of accredited investors, but you can only have accredited investors. So all your investors have to essentially be high net worth or high income individuals. But with that, you're allowed to do general solicitation. So you can do Facebook ads, you can put a billboard, you can shout it to the world. So your big trade-offs that you're dealing with 506B and 506C is with 506C, you can tell everybody, but you're limited to accredited investors only. With 506B, you can't do general solicitation, but in exchange of giving up, casting that wide net, you can have up to 35 investors that are not accredited. So that's the big difference between the two of them. So again, when I'm counseling clients, I say, who do you think is likely to invest? If most of your investors or most of the people you think are going to invest are accredited, then it might make sense to do 506C, and that way you can get all those people in your network that are accredited. Plus, maybe they have friends that you don't have a pre-existing relationship with, or maybe you do want to advertise. You could advertise and potentially get other people as well. If most of the potential investors in your network are not accredited, and maybe even if some of them are, but if all of them are not, then you might say, you know what? I've got a good amount of accredited investors that I know and have a pre-existing relationship with, so I could get them in this. But then also I've got a few people that are not accredited, but I again have that pre-existing relationship. So with a 506B, I could have them in that as well. So that's kind of the balancing act that you do when you're trying to determine between 506B or 506C. And again, there are multiple exemptions. Probably if you are even moderately interested in this space, you might have recently heard about Regulation Crowdfund. That had some expansions into its criteria. And so that's an exemption that could work. There's also Regulation A has had some nice expansions as well. So depending on what you're doing, that's one that could work as well. And again, there are other exemptions as well. But if you are selling a security, which again is an investment in a common enterprise with an expectation of profit primarily from the work of others, then you either need to have an exemption or you're going to have to register it. So that's all I've got kind of for the canned spiel. But let's open it up. Are there any questions?
I have a question, if you don't mind.
Let's open up some questions. James?
Yeah, sure. Thanks. Thank you for your time, Nick. I appreciate it.
Mm-hmm.
When my partner and I were starting our company, we figured an LLC would be the way to go. Our CPA recommended an SCorp, and I kind of understand the differences, but can you just touch on a couple of key differences between SCorp and LLC?
Yes, great question. And that's kind of one of the exact scenario where I was saying is particularly talk with your tax planner, because there are some situations where for tax purposes, an entity might be better. So an S corporation, you create it as a regular corporation. So when you're filing it with your state, you'll file it the same way you do a normal corporation. The difference between that and a typical corporation, or technically it's called a C corporation, that's the one we normally are thinking about. An S corporation, you have checked the S election. And what that means is on the tax form, there's a part that says, hey, would you like to be taxed as an S corp? And you check the box, and now you're an S corp. Now, what does that do? Well, as I mentioned before, a normal corporation is going to be subject to double taxation. So the corporation is taxed, and then when it passes that money on to the owners are taxed. With an S corporation, it's going to look and function a lot like an LLC in that the S corporation itself is not taxed. Instead, the individual owners are taxed on whatever the S corporation receives. So they have a lot of similarities in their characteristics. Some important distinctions. An S corporation still is a corporation, and corporations have strict management. And so with an S corporation, you're going to need to have minutes. You're going to need to do votes for certain things and have a record of that. For instance, my law firm, it's an S corporation because in California, professional services cannot be LLCs. And so I had the option of basically just being a corporation in that situation. So my law firm is an S corporation. I'm the single shareholder, but I still have to have a record. I have a meeting with myself and say, we voted to give Nick this salary. We voted to do this, or we voted to do that. And I have a paper trail of all of that, because as a corporation, I'm required to keep those strict formalities. Whereas an LLC, you might be required to if your operating agreement states that, but in most cases you wouldn't be, or you'd have the ability to set your LLC up to be a lot more flexible. Some important things to understand about an S corporation is you can only have one class of shares. So even in syndications, sometimes you might have multiple membership classes, or in regular corporations, you have, preferred stock and things like that. With an S corporation, everybody's on equal footing. So one class of stock. You are only allowed to have up to 99 shareholders. Those shareholders must be natural persons. So you can't have another S corp invest into an S corp, or another LLC or something like that. Certain retirement accounts or nonprofit entities might be able to, but generally it must be a natural person. So a person like you and I that's born that is the investor, and you can't have any foreign investors in an S corp as well.
I see. You just actually, I don't mean to, real quick, you just actually raised another question. I know about taking minutes of, the company's events. I have a whole binder that was sent to me when we filed. Those notes that we need to take, should that just be basically when we finally purchase a property at that point, when we're taking money from investors and things like that, or should we have been, notating what we've been doing up to, from the start up to that point?
Part of it also, again, depends on what your corporation, your S corporation governing documents say. Okay. You can, in some scenarios, depending on what it is, the S corporation could give authority for somebody to have kind of day-to-day authority. So, if we're trying to just operate the general business of the company, you don't have to take a vote for every single thing. You can just vote to empower this individual to make those decisions.
Gotcha.
Yeah, so that, I hope that kind of answers the question.
Yes, thank you. Thank you for your time.
Okay.
I think Nicole can piggyback upon that. You want to unmute and ask the question, Nicole?
Oh yeah, it was basically that same thing. Like if I'm a single member LLC, taxes and S corp, if I still have to do like those same meetings and minutes and that kind of stuff, because honestly, I have never done any of that.
So as an LLC, the duty is probably a bit lower, because again, generally LLCs have a bit more flexible management. You still are, because the LLC is an entity, so you do need, there still are at least certain things that you should have minutes for. Now, in practice, this comes into play either when, if you have multiple members and there's a fight, then you'd have to see, was this action authorized or not? And then also if you're getting sued. And so here's for Nicole and for others that are asking, here's the reason why, even if you're a single member entity, here's why you want to have this, is that if you get sued, one of the things that a lawyer might try to do is what's called piercing the corporate veil. The corporate veil is the limited liability shield. And so if you are not treating the entity as a separate entity, then the court might say, you know what, you didn't treat that as a separate entity. So when it comes to pay bills, we're not going to treat you like a separate entity either. This happens most commonly through what's called commingling of assets. So with everybody, if you have an entity, you 99% almost absolutely must have a separate bank account. At the very least, you need to have a separate accounting and be able to say very clearly which assets belong to the entity and which assets are personal ones. Easy way to do that is just to put the entity assets in one bank account and your personal ones in another. So getting back to what I was saying, if I were to sue you for whatever reason, one thing that I might do is try to pierce the corporate veil so that now I can not only sue your entity, but also come after your personal assets. And so one thing that I might do when trying to do that is say, okay, have they followed corporate formalities? And in a discovery request, I might request the annual meeting minutes. And if you don't have those, that might fuel my claim that you were not treating the entity separately. And therefore, since you weren't treating the entity separately, I should be able to go after you personally. So that's kind of why it's important to follow those formalities, even if you're a single member entity.
Thanks. Harry, you have a question?
Oh, yes. Yeah. Thank you. Yeah. Thanks, Nick. That was a brilliant presentation. So I have a question about foreign entity registration. I'm in Canada and I'm actively seeking multifamily assets in the US. So what's your suggestion? Definitely SCorp is not an option for me. And Canadian CRA, it does not recognize LLC as a pass-through entity, but it does LP. It does recognize LP. So what's your suggestion? Is there any nuggets you can share in that situation?
I can share a few. One clarification I do want to make, though, when I was referencing foreign entity registration, an Oregon LLC operating in California would be considered a foreign entity as well. So it's just an entity that's formed in a state and operating in a state that it's not formed in. But for your question, I don't deal with cross-border stuff quite a bit. I do know, I have learned from clients that in Canada, LLCs, the taxation apparently is really bad. Some things that I have done or clients have worked on is what's called a wraparound. It gets very complex, but essentially how it works is that we created the US-based private placement memorandum for their syndication. And then they had a Canadian syndication attorney do what's called a wraparound. Basically, they create a Canadian PPM that is basically fed by the US one. And in that, I think they had it set up as, I think they had trusts and limited partners on the Canadian side set up. That's about as far as I can tell you. Unfortunately, I wasn't intimately involved with what was happening on the Canadian side. I know that there are ways around it, but it does for sure add complexity to it. Now, as far as you just investing in US ones, if you were able to create a US entity, then you technically would not be a foreign investor. So if you created, let's just say, a limited partnership in California, you could invest as that California limited partnership, and that California limited partnership is a US citizen technically. So that's some ways that some Canadian clients have navigated the cross-border issues as well. With that though, in order to create a US-based entity, you do need to have an ITIN number. That's basically the social security number. And in order to get that, you have to have a need to file a tax return. So essentially you'd already have some US investment that you've made money and you're filing a tax return, then you can apply for that ITIN. And once you have that, then you're good, create a US entity and just do your investments through that. And that's about as far as I can go on that topic.
Oh, no, that's great, And I was thinking actually a little more simplistic, that the Canadian entity owns the US entity, and the US SCorp would have a LLC in Wyoming, and that Wyoming can have wherever the asset is, So it will pass through from one LLC to another LLC to the SCorp. And then Canada and US has a treaty with regards to taxation. So whatever I pay here in the US, I get a credit back in Canada. So this is one, and the other one would be creating an LP, But anyway, this is thank you for sharing. Yeah, I appreciate it.
Yeah, that sounds like it would work. Again, I don't know the tax issues, but that sounds like it would work. You kind of made me think of one thing that I didn't talk about in the presentation. When I talked about the foreign entity registration, if you are acquiring an asset, you're going to need a entity in that state. Because if you're having the real estate, you're going to need an entity in that state where the real property is, because you're very clearly conducting business in that situation. And so that's something that syndicators sometimes do not fully understand or recognize, is that wherever the property physically is, you'll need some sort of entity there as well.
Thank you.
Harry, so San, who's in this meetup, is also US and Canadian dual holder, and he might have some ideas for you. So I asked him to leave his, oh, here he left his LinkedIn information, so get connected and you might get some information from him. Okay.
Brilliant. Thank you, Joseph. Appreciate it.
No problem. Okay, I'll go back to Jay. Can you unmute and ask a question?
Yes, thank you, Nick, and for today's presentation. This is awesome. And thank you, Joseph and Nico, put this together. It's great. Thank you. My question and Josep's kind of like piggybacked as well. I was wondering, you know, the pre-existing relationship is a little bit confusing to us, and where is that before the deal under the contract is considered as a pre-existing relationship, or what if prospective new investor jump in, who is a friend of already pre-existing relationship who's investing in the deal? Is it considered as a pre-existing relationship, or sometimes, you know, friends are talking about their investing deal and syndication and wanted to talk to one of the general partner, but since they are not pre-existing relationships, so they are not really qualified to invest. Would you mind, you know, define that term a little bit?
Yeah, so in the scenario you mentioned where you have somebody that you do have a pre-existing relationship with, and they have another person that they have a relationship with, if you don't have that pre-existing relationship with them, then it's not a pre-existing relationship. Regarding timing, definitely anytime, the moment you have either an LOI or PSA, if you didn't have a relationship with them at that point, it's not going to be pre-existing. Now, when you're kind of doing your early due diligence, I'm not talking about when you're under contract doing due diligence, but when you're just vetting the property, it's a bit gray as to whether you have it or not. What I tell clients, I think I might have mentioned this, but I'll say it again. I say, you know, you meet them the first time, or have the meeting with them the first time, talk very generally. This is my investment company. These are the markets we look in. These are the general parameters and metrics we're looking for, but speak very, very general. Then wait 30 days, meet them again, talk with them. What types of investments have you done? What are your finances like? What types of interest do you have? What's your risk tolerance? And on that second meeting, what you're trying to do is figure out, is this person accredited, or are they sophisticated, or neither? Because a pre-existing relationship, essentially what that means is that even if they invest, you're going to have them fill out a questionnaire or potentially have a third party verify that they're accredited or otherwise. But before that, you should already know. You should know when you send them that questionnaire, you're going to know whether they're going to check accredited or sophisticated, and you're going to understand the reasons why. So you have that first meeting where you're generally talking about your company, just being very general, not talking about specific deals. Wait 30 days, talk with them, get to know what their finances and their investment strategies and that sort of thing is. And then the next meeting, which doesn't need to be 30 days later, then you can say, okay, here's the deals that we've had. Here's the ones that we're looking for or looking at, that sort of thing. Did that help a little bit? And
Yeah, thank you.
What I will say is that the answer to this isn't super clear.
Right.
I try to clarify it as much as I can, but it's not the clearest answer. The actual answer is not extremely clear.
I think on SEC website regarding 506B saying substantive word, does that mean all investors should have a substantive relationship with the operators?
Yes, if you're doing a 506B, anybody who's remitting funds, the issuers need to have a pre-existing substantial relationship. The substantial part means that you understand whether they're accredited or sophisticated, and you understand the general reasons why. That's what the substantial part means.
Thank you, Nick.
Nick, that doesn't necessarily mean that the investor should know every single one of the GP, right? They could
Correct. It doesn't necessarily have to be everyone. It needs to be somebody that's in the GP group.
Okay. So my next question is, can you still talk about your 506B deal to someone you don't have pre-existing relationship, but knowing that you're not gonna have him invest in your deal. Is that still some sort of violation? You have no intention.
Can you give me a kind of, well, why would you be doing that?
So something like this. So we have a deal presentation of our own deal, right? 506B. So it's a legit deal presentation. And I'm bringing my friend, but that friend's friend wants to take a look what kind of deal we do. But I have no intention of having that person invest into our deal because I know we don't have any pre-existing relationship, but I just want to sort of have that person taste it.
You can do that. I'd say tread lightly. You could run afoul of things. You'd want to make it very clear that you are not soliciting them. They are not eligible to invest. You're not trying to get them to invest. And so the part where I'm saying you want to tread lightly is that it, talking about it could cross over into solicitation, and that's what you want to make sure you're avoiding.
Gotcha. Okay, thanks. Steve, you wanna unmute and ask that question?
Yeah, sure. Hi, thank you, by the way. It's been really informative. My question was, I'm sort of a newbie to this, so I just might be a dumb question, but I heard that there's some debate or conversations around where like an LLC versus just using like land trusts might have different pros and cons, and if so, what would those be, and are they state specific?
Good question. So when I've seen this, just like in message boards and whatnot, talked about, I think it's talked about incorrectly. So there are land trusts. There's a land trust that has a lot of different meanings. The more typical land trust is where either the government owns land or a nonprofit owns land, and they are trustees of that for a certain purpose or specific aims or goals. When people are talking about this, I think what they're saying is, should I put my land in a trust? And a trust in and of itself does not specifically have limited liability protection. And so if you're doing it for that reason, it's not going to be helpful for you. And trusts are very helpful for estate planning purposes, but not so much for limited liability purposes. Now, if you're referring to a Delaware statutory trust, I don't work a lot with, or don't work with those, but from what I know about them, they have some interesting perks. Delaware, again, trying to be the state where people go with real estate is, well, I'll briefly, in case people are not familiar, there's a concept called a 1031 exchange. And what that is that if you hold real estate, let's say I bought it for $100 and then I sell it for $1,000, I'm going to have to pay $900 in tax on that real estate. And I don't want to pay $900 or tax on that $900. So what I could do is I can sell it and do a 1031 exchange. And as long as I basically take that $900 and invest it into other real estate, I'm basically kicking the tax burden down the road. So 1031 exchanges, at least traditionally, only work for actual real property. So I'm buying physical real estate assets. If I were trying to invest into a REIT, which is a company that then invests into real estate, that wouldn't work because technically I'm buying a security, not real property. Well, Delaware said, hey, we're going to create a thing called a statutory trust. And we're going to say that a Delaware statutory trust is real estate. It's not, but they've just said that. And the IRS said, okay, sure. And so what you can do is that I could sell a piece of real property and then take that money and invest it into a Delaware statutory trust that might be invested into other parts of real property. And that counts as a 1031 exchange. So it can be helpful with that. Again, I don't work specifically in that. I've read about it. I've talked with people about it. It's not something that I specifically do. But for that purpose, Delaware statutory trust can be very helpful because, again, instead of having to buy real property, you're able to essentially buy a security that's investing in real property. So it gives you a little bit more flexibility.
Great, thank you very much.
Mm-hmm.
Okay. I have one question. It looks like that's the last one of the chat box. If you have more, you could speak up. So how many LLCs are usually formed for a typical syndication? Let's say about GP group and then about 20, 30 people of an LPs.
Typically, it's going to be 3. you're going to have one, this sometimes referred to as an SPE, single purpose entity, or specific purpose entity, or special purpose entity. That SPE is going to be the one that holds title to the real property. So that one's going to be formed wherever the asset specifically is. That's what you need to do, because if you don't form it where the asset is, and say you formed it in Wyoming, you're going to form it in Wyoming, pay the filing fee in Wyoming, and then you're going to have to, the foreign entity registration is essentially the same process as creating the entity in the state itself. And so to avoid that duplication there for the SPE, that should be formed wherever the asset is. So that's one LLC. Then you're probably going to have two more, at least how I like to set them up. So you'd have two more LLCs. One of those LLCs is the fund that the investors are investing into. And within that, you might have multiple classes of membership. Some of my clients will have, 3 or 4 different types of return structures, depending on what their investors are looking for. And so they might have class A, B, and C that their investors will be buying. Then they're going to add class D. Class D is the management class. That's if you're in this industry and you've heard the term GP, LP, essentially that class A, B, and C, the investor classes, that's our LP. And then that class D, the management class, that's our GP. The management, I like to set it up to where the management class is held by the third entity. So the reason that I do that is for, at least for me, I'm representing my clients who are the issuers and the managers of the GPs. And so I do it that way, is that if the investors are not happy or if something goes wrong and they want to sue the manager is an LLC. And so the issuers are going to have limited liability protection if something goes wrong with their syndication or their deal. And so you have that SPE, the single purpose entity that's holding title to the property. And then within the syndication fund itself, you have one LLC that's the fund and one LLC that is the manager of the fund. And you can get more complex than that. I've done some that had like 6 or 7, generally not needed. Even in that situation, it wasn't needed, but the GPs wanted it, so we did it.
Thank you. Thank you very much. Okay.
This is, so Nick, first of all, the questions can come, I can ask a million more questions, and I think that a lot of people listening can ask a million more questions too. You are a wealth of knowledge, and I think that the takeaway tonight is that we can't do this alone. So people, like, just by everything that you're saying in the depth that you're, and I can tell you're treading lightly here and there. You're like, what do these people know? What do these people not know? So at what point, like, I want to wrap it up in a minute, but at what point do we come to you saying, look, help me out here. I have this situation. I would like to buy X property. How should I structure it between X partners or et cetera? At what point should we contact you?
If you're talking about doing a full-on syndication, at least reach out to me if you have an LOI. At least let me know so we can kind of start figuring out what's gonna happen. I usually tell clients, when you're pretty confident that the due diligence is going to be satisfactory to you, that's when we should get started. It takes me and my team, we've done one in 10 days. I don't want to do one in 10 days. It was chaotic. Generally, we more so are aiming for about 3 weeks, and realistically, it often takes about 5 weeks. On our end, we can do it in 3 weeks, but if there's if the client has if we have a question or need information and the client takes 2 or 3 days to get back to us, that's 2 or 3 days that we're not advancing their file forward. And so that's how we end up being at about 5 weeks. But we can very comfortably do it in 3 weeks. And so that's why I say, if you're confident that the due diligence is going to be good, then we should get started then, because it's going to take us 3 weeks to get the documents ready. And then you still have to then send that out to your investors and have them wire the funds in. And so you're going to need a little bit of leeway before the actual closing date on the asset as well. So yeah, it's sooner the better, but it's going to take us, plan on it taking us at least 3 weeks. And then you're probably going to want to have at least 2 more weeks to allow your investors to review all that and wire the funds in, and probably even more than that realistically.
Awesome. Awesome. Wonderful answer. Joseph, do you want to wrap it up?
Sure. I think it was a great session. Nick, thank you very much. From the basic questions to a little higher probably more sophisticated questions. Thank you for answering all that. I'm sure we could have gone to 2-3 hours if you bring all the questions, but given the time frame, it was a great. Thank you very much for coming, and thank you very much everyone for coming and making this show great.
Nic, can we get some contact info? How can people reach out to you? And I'm also going to add that into our follow-up email as well.
I'll put it in the website right now, or put it in the website into the chat. If you go on there, you can message us directly. You can also schedule a free 15-minute consultation through the website as well. So that's probably the best way to get in contact.
Great. Well, we're gonna send out an email with his link together as well, so you'll get that too. It's okay. Sang asked about the fee structure. Is that something that you could talk about it here, or is it you prefer more as a consultation call?
No, I can talk about it. So our fees, I like to do a package so that that you'll know exactly what you're getting essentially versus the hourly rate. So depending on exactly the structure, it's going to vary, but our base rate ranges from $7,000 to $10,000. You're also responsible for the hard costs. The more expensive ones are if you're doing a fund versus a direct syndication. And quickly, the difference between that is with a direct syndication, you're saying, hey, I'm raising capital for this specific asset. Whereas a fund, you're saying, hey, I'm raising capital and I'm going to find assets. So we haven't necessarily identified the assets. Or maybe I'm raising capital for this asset, but then I'm also going to find some other ones. And so if you're doing a fund where they're unidentified, it's going to be a bit more. But for direct syndication, it's $7,000 plus the hard costs. Hard costs are around $500. That's for the entity filing fees. If you need a registered agent, it's for that as well. And what you get for that package, or at least for the syndication one, we'll create those 2 LLCs that I mentioned. And so we'll do the articles of organization. You get an operating agreement. We get the tax ID, we do the promoter transfer, minutes of the first meeting. So you have everything you need to get the LLCs up and running, open bank accounts and all that sort of stuff. Then also you'll get a PPM. And so what we do is we send a questionnaire. It's about 50 to 60 questions. So I warn you guys about that now because it is long, but it's important because it makes you think about the deal, the inner workings of your deal. And it's also information that me and my team will need. And so we'll send you that question, and our goal is to get you a draft of the PPM in 3 to 5 business days. And so far we've been able to hit that with everybody. So you'll get a first draft of the PPM. That one almost always is going to have some questions on our end that we have, or some things I want you to look at. So we'll highlight those questions and issues to you. You and your team will review that, and you'll probably have some questions as well. And then we can get together and talk through all those issues. And you'll get a second draft. That usually gets us about 90% of the way there, if not all the way there. And if not, no worries, you get a third and final draft as well. You also get, I forget the exact number, but it's about 3 hours of emails, phone call, advising time. I set the cap at 3 hours just because before I had the cap, I had a client that was kind of calling every day. And for a flat fee, I'd love to talk with you, but for a flat fee, I can't be talking with you every single day. So I put that cap in, and then once I put it in, I've never had an issue. So that's mainly there to protect me and my team from being overworked. But if if it's like 3.5 hours, we're not going to charge you extra for that. But if it's like 10 hours, yeah, we're going to charge extra for that. So you get some advising time. Then there are also 2 documents that we have to file with the SEC, and we take care of those 2 filings as well. And so from my legal opinion, it includes everything that you need for a syndication, except it doesn't include the blue sky notice filings. What that is that if we're doing a Regulation D, for instance, that is federal law. And so we're not required to follow each state's individual securities laws. However, each state does require that we notify them if we have investors in their state. And when we notify them, they say, if you're taking investors in our state and you're notifying us, you got to pay us some money. And so it can get pricey, and not so much from us, but from those blue sky notice filing fees. Most states range from about $100 to $500, but there are some states that are in the $1,000 range. And so if you're trying to ballpark and estimate it, I say plan on about $600 per state. It won't be necessarily absolutely accurate, but it'll get you pretty close in the ballpark. For our fees for doing that, we kind of have a tapered fee schedule because doing 4 versus 8 is not double the work. It's more work, but not double. So what we charge is $100 each for the first 2 states, $50 each for the next 4 states, and then $25 each for each state thereafter. Except Maine, New York, and Arizona, I believe those ones are about $250 because their process is a bit more involved.
Great. That was like what, 3-minute nutshell what you do.
Yeah.
Great.
Awesome.
Awesome. Thank you very much. That was great show. And we will see you again in a month later.
Great meeting you all. Thank you so much for having me. My pleasure. Very much.
Thanks,
being
everyone.
here.
Thank you.
Thank you,
Nick.
guys.
Thank you,
Thanks,
guys.
Nico.
Awesome.
Hey, thanks, Nick.
Thanks, Joseph.
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 Thank
you
you.
all.
Thanks, Nick and Yosef.
Thank you, Mike. Thank you,
Thank
Tommy.
you, guys.
Thank you, Lou. Hi, Jamie.
Yeah, thank you, everyone. Thanks.
Hi, Steve.
Bye.